Good morning. I'm Judge Ryan Sullivan. I'm going to be handling the hearings today. Before we start, are there any requests, Ms. Casso, on cases you'd like to have heard early on in the docket today?
No, Your Honor.
All right. Good morning, Ms. Lopez. Any requests from cases you'd like to hear early on today?
No, Your Honor, not early.
All right. Then we will begin with the jails list. First appearance for Sail Janufu.
Mr. Danifu waived his appearance, Your Honor.
All right. Are we going forward without him then?
Yes, Your Honor.
Okay.
It's just on the fugitive matter.
All right. All right. So I do see that, and probable cause has been found, and then we will set him for his next appearance once a criminal complaint is filed. We have a first appearance from Miguel Hernandez Taribo.
Making his way up, Your Honor.
Good morning.
Morning.
In this matter, probable cause has been found. There's an allegation of fugitive from another jurisdiction. So, sir, we'll bring you back in a few days once your criminal complaint is filed for further proceedings.
Do we know like what charges are filed?
Yep, sir. Well, the charges will be filed in a few days. They're alleging you're a fugitive from another place. So
Oh, that's all you guys know.
that's all I can explain to you right now. Yep. We have first appearance for Nicholas Johnson.
Mr. Johnson waived his appearance on this.
Right. This is also a fugitive matter. Probable cause was found. We'll bring him back in a few days once the criminal complaint is filed. We have first appearance for Misty Aguilar.
Your Honor, we're waiving her appearance. You know, she's got matters out of the competency court, so I would ask that we set an interim bail today and then see what charges get filed.
All right, so she's pending with the competency court. Your recommendation for an interim bail, Ms. Casso?
Your Honor, the state is seeking $10,000 with pretrial services supervision and no contact with the fireside market.
Ms. Lopez?
We'll submit.
All right, given that she has the other competency matters pending, I'll do that. It'll be $10,000. That's interim, it's bondable, or 10% cash. I'm not going to include any other conditions. If she's in competency court, I assume that they are handling whatever conditions may be necessary for her. Next, we have first appearance for Anthony Diaz.
Yeah.
And Your Honor, in this case, we're identifying a conflict. I've sent this information over to the alternate. He is in custody on other matters. He's got a probation violation hold. Am I thinking the right person?
Yeah, it's a juvenile.
Oh, I'm sorry. I am incorrect. This is not the case that I was thinking about.
All right.
Yeah.
Probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Your Honor, the state's not going to object to releasing the defendant on his own recognizance. He does have that juvenile hold. I don't know what's going to happen with that, but on this case, we are asking for pretrial services supervision and testing for controlled substances.
So I am going to release you, Mr. Diaz, but your case is not over with in Reno Justice Court. I'm going to give you your arraignment date. Whether you're in custody or not, you're going to have to be here. I don't know if that juvenile hold will be released, but it will be April 1st at 9 a.m.
All right.
And given the moderate risk score, I'm not going to impose any other conditions other than you have to go down for Reno Justice Court monitoring within 1 business day of your release. So as soon as you're released from that juvenile hold, you've got to come down to Reno Justice Court and make sure you make that court date, or else next time you'll get arrested and I may not release you at that point without bail.
Yes, ma'am.
All right. Next we have a first appearance for Eric Flora.
You can go.
Good morning. Probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Your Honor, state seeking $20,000 for Mr. Flora. along with pretrial services supervision and a no contact order with the park where this occurred, which is Plumas Park. Although he scores moderate on the risk assessment, the defendant was on probation out of the Second Judicial District Court when this occurred. That was related to a felony conviction for grand larceny. He's got numerous probation violations out of Carson City related to some misdemeanor offenses there. Petty larceny, or excuse me, a possession of drug paraphernalia in 2022. He's got a theft conviction in 2016, a felony burglary conviction in 2016 out of Las Vegas, petty larceny in 2014, and then another felony controlled substance conviction, looks like out of Arizona in 2011, along with an organized retail theft ring conviction out of Arizona that same year as well. So definitely a convicted felon on probation when this is committed. So the state believes the $20,000 with those conditions are appropriate.
For the defense.
Your Honor, my client reports that he's been doing relatively well in probation. He relapsed when this had occurred. Otherwise, he's staying at Life Changes with Lisa Moore. And so our request today is for the court to consider allowing for, perhaps a bail, but also for him to be released back to Life Changes if we can get him back. IAP can take him there through DSU. And so we're requesting that he be allowed to go back to Life Changes with supervision, testing for drugs and alcohol if that's what the court thinks is appropriate. He wasn't arrested with any controlled substances, but it is our belief that any concern that this type of behavior could happen again would be alleviated with testing for drugs and alcohol, given that this was a relapse.
Well, I see he's on parole and probation. There's lengthy criminal history. He scores a moderate. I'm going to set the bail. I'm going to set it at $8,000. That's bondable or 10% cash.
Can't make any bail though, ma'am.
Sir,
And I understand that, sir. I'm not done. I'm going to indicate no contact with Plumas Park. He's going to comply with parole and probation. If parole and probation decides to lift their hold, I will indicate he can be directly transported to treatment by any agency, but that's only if they lift their hold on him. So those will be the conditions in place if the hold is lifted. Thank you. Next, we have a bail hearing from Michael Neal. Good morning. Probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Thank you.
Your Honor, state is seeking $1,000 bail for this defendant with the condition that he stay away from the Amtrak station and that property. As you can see in the probable cause declaration, he continues to be a problem returning there, even when told not to. He scores high on the risk assessment at a 12. His criminal history is what you would think of these type of nuisance offenses over and over. He was convicted of possession of drug paraphernalia out of Reno Justice Court in 2024. Citations out of the Reno Municipal Court for sitting or lying on a public sidewalk with associated failures to appear. That was in 2024 as well. More trespassings in 2023, again, out of Reno Municipal Court with associated failures to appear for community court hearings. So the defendant does have compliance. It kind of goes on like that. He does have obviously issues complying with court orders as well as continuing to show back up at this property. So the state believes the $1,000 with that condition is appropriate.
I understand the state's request, but I don't see that there's any violence here. I believe Valdez Jimenez compels me to release him. I'm going to release you, Mr. Neal, but your case is not over with. I'm going to give you your next court date. You've got to show up at Reno Justice Court April 1st at 9 a.m. and you've got to stay away from the Amtrak train station. No contact. You can't go back there. And if you can't follow this court order, then next time I'd have no choice but to do something that may keep you in the jail. Do you understand that?
yes, ma'am.
All right. Thank you. Next, we have a first appearance for Christian Diaz Lopez.
Oh, he was coming. Oh, no, you're right. He waived his appearance, Your Honor.
All right. Probable cause is found. The public defender is appointed. Let's start with the state.
State seeking $15,000 bail for this defendant, along with pretrial services supervision with a no alcohol and testing clause for the same. As you can see, he scores 11 on the risk assessment, a very high score, 2 of those points being for failure to appear and prior violent criminal convictions, also receiving 2 points. In this matter, he battered a police officer where he appears to be grossly intoxicated upon them contacting him. Unfortunately for Mr. Diaz-Lopez, he's had many opportunities to get his substance issues under control. He was just in 2023, he was arrested for residential burglary, got a chance to do specialty court, and he did it for many years. He ended up graduating in September of 2025 after a lot of ups and downs, but he did graduate, and that case ended up being dismissed. In 2023,
outside the door.
he had another burglary that was reduced to a trespassing, looks like out of Reno Justice Court. He did cap court. He had treatment there, and his history goes on and on. He has battery, he has obstructing and resisting charges. He's got, looks like his criminal history goes back to 2016 with the battery conviction. The defendant does have prior violent convictions as well, those batteries. So the state does believe that the $15,000 with those conditions is appropriate.
For the defense.
Your Honor, my client reports that he doesn't have any money that he could post towards bail, whether it's 10,000 or 10. But he does say that he's been staying at WellCare most recently, and he did, he left. He was intoxicated. The state is correct. If he goes back to WellCare and he's testing for drugs and alcohol, and he's checking in the way he's, supposed to, and we have him on supervision, I think these types of offenses are going to be less likely. I understand the state's position, that he's had plenty of opportunities to get clean. I think he does better when he is actively being supervised. It's different when you're not being held accountable, even though he's in a facility. So I think, with the testing and the supervision, he says that he knows what it is that he needs to do. He recognizes that if he's on supervision and he drinks, he can be remanded. He says that he wants to go back to WellCare. So we're asking for IAP transport if we can get him into a bed.
So given his lengthy history, his lengthy problems with drugs and alcohol, I believe a monetary bail is appropriate, but I'll set it at $3,000. It's bondable or 10% cash. If he posted, he needs to be monitored by Reno Justice Court. I will include direct transport by any agency to treatment or sober living. So if he can arrange that, I'll allow that to happen. Otherwise, that bail remains. Next, we have first appearance for Christopher Dilbert. Good morning. Probable cause was previously found. The public defender was previously denied. And Mr. Dilbert, let me just ask you a couple questions about your income, sir. Do you currently have a job? And if so, how much income are you making per week?
I have a job about $1,000 a week, but I just paid mortgage. I don't have any extra money to bail out.
Okay, how many people are in your household?
2.
All right, so I believe, sir, given that you're on the cusp and that you indicate after paying your mortgage you don't have any more funds, I will appoint the public defender to represent you. You're free to hire an attorney anytime you like. This doesn't change that, but I will appoint the public defender's office.
Thank you, ma'am.
Let's begin the bail hearing with the state.
Thank you, Your Honor. State seeking $100,000 for this defendant, along with pretrial services supervision. We would ask for a no contact order pursuant to the case for this defendant, for the victim. We are also asking for a no firearms or weapons clause as well. The state believes that amount of bail and those conditions are appropriate based on a couple of factors. Number one, the underlying facts of the case. You can see the defendant's conduct outlined in this probable cause declaration, making threats against his former mother of his child, girlfriend, and then the eventual actions that he takes in this case, following through with those threats. What we know about this defendant is he is currently on pretrial services for 2 outstanding felony cases. One of those being a battery causing substantial bodily harm. It's currently pending in Sparks Justice Court. He's got a prelim set for that on April 6th. He also then picks up a felony embezzlement plus a possession of a controlled substance arrest. Those were combined into one case. He's currently on pretrial services for that case and pending a prelim on April 6th. In both of those cases, he's had numerous pretrial violations to include positive tests, abnormal tests, and he's FTA'd or failed to appear for testing in those matters. In addition to that, he's got misdemeanor convictions for petty theft and false ID. Back in 2013, he has arrests out of California for battery and DUI. There's no disposition. He does have misdemeanor convictions for battery back in 2009, another battery in 2007. He's got a felony conviction for possession of stolen property back in 2004 out of California. We were able to speak to the victim in the case, and as you can imagine, she is terrified of this defendant. This has been an ongoing issue. She did receive a TPO, I believe, yesterday or today. So that is why we're not asking per statute for the no contact order. That TPO covers not only herself, but her 2 children, one of those children at issue in this case. She said she is very afraid of this defendant, that he has issues with drugs, controlled substances, alcohol, and mental health, which contribute to his behavior. She's extremely, what she said is she's extremely concerned about defendant contacting her children. And so again, that's why she sought that TPO. But based on her information, as well as the facts of the case, the state does believe a higher bail is appropriate, coupled with his history, current history, with that $100,000 with those conditions.
Other defense.
Your Honor, in addition to this case, my client is pending those 2 other cases that the state mentioned. He is pending bail revocation hearings in both of those matters. He has posted a significant amount of monetary bail on those 2 cases. And as the court already noted, you know, even though he's working, he does own his own home and he pays mortgage on that. And he's struggling financially just to kind of stay afloat. I understand that this is an aggravated case and he's already on supervision. However, you know, while he scores an 8 moderate on the risk assessment, looking at his personal information that's able to be verified, he's actually probably overscored on the pretrial risk assessment tool. We believe that there are conditions that can ensure the safety of the community. Obviously, as the state pointed out, Mr. Dibert struggles with substances. I know that he's been on testing and supervision before. I don't know how often he had been ordered to testing. I think it was random. And I think that obviously he needs increased testing, which he is willing and able to do. We are also asking that the court consider his financial position and the 2 cases that he has pending that are close to prelim. We're working on a resolution in both of those matters as well, that our office does represent him on. So with all that said, Mr. Dibert asks that the court consider releasing him on this matter, understanding that it is very likely that the bail in the other 2 matters is going to be revoked and he's going to be looking at a significant number on those. Any conditions that the court thinks are appropriate in this matter, he's willing and able to comply with, including no electronics, no social media, obviously no contact with the mother of his children. And if the court does think that monetary bail is appropriate, understanding that he has those other 2 cases that are still pending, our recommendation would be $25,000.
He's already on supervision for very serious allegations, and this behavior is also very serious and very concerning against the alleged victim. And he talks about other things related to the legal system. And so I believe there is a risk to the community. And he also has had numerous violations while he's on the pretrial supervision, not including this. I hear that Ms. Casso indicates that he's been testing positive for drugs and alcohol and has still been given chances to continue out of custody. So at this point, I believe that a very high bail is warranted due to the risk to the community. I will set it at $100,000. It's bondable only. No contact with Caleb Bloom, that's pursuant to statute, NRS 1784845 for 120 days. So that includes phone calls from the jail. They are all listened to and recorded on a regular basis. I hear them being brought up frequently. So do not reach out to her from the jail. It will only be used against you. There will be pretrial services supervision. You've got to comply with any family court orders that are in existence, no weapons, and testing for drugs and alcohol. Thank you. Next, we have a first appearance for Joel Fuquay. Good morning.
Morning.
Probable cause has been found. Sir, you indicated you're going to hire your own attorney. I do not see anyone here for you. Were you able to reach out to anybody to represent you?
Not yet.
Okay, so, sir, I see you own your own company. How much income do you make per week?
Right now, not much. Because I had a business situation that happened with a previous partner in June, which is down to a lawsuit and rebuilding my company right now that I've had for 24 years.
Okay, sir, so and how many people are in your household?
5.
Okay, so sir, do you estimate you're making under perhaps 1,500 a week?
Combined or individual?
Just for you, sir.
Yes.
Okay, so I will appoint the public defender to represent you. That doesn't stop you from hiring your own attorney. You can hire someone anytime you like, but given your income, you qualify. Let's begin the bail hearing, starting with the state.
Your Honor, even though the state is very concerned about the facts of this case, the fact that the defendant scores 0 on the risk assessment, he doesn't have any adult criminal history, the state is not going to object to releasing him on his own recognizance. We would just ask for check-ins.
All right, so sir, given that you don't have criminal history and you score 0 on the risk assessment, I am going to release you, but let me make this clear. That does not mean this case is over with. I'm going to give you your next court date right now. You have got to show up at this next court date. It's going to be April 1st at 9 a.m. And you have to check in with Reno Justice Court by Monday at 5 p.m. So you've got to come down to Reno Justice Court by Monday at 5, check in with us, make sure we have your contact information, and answer any other questions we may have about how to reach you, and so that we can make sure you are aware of all your future court dates.
Okay.
Thank you.
Thank you.
Next, we have a first appearance for Adrian Jeriquet.
Hello, Your
Good
Honor.
morning. Probable cause has been found. The public defender is appointed. Let's start the bail hearing with the state.
Your Honor, state seeking $10,000 bail for this defendant, along with pretrial services with a no firearms or weapons clause. That is based on his risk assessment of the facts of the case, plus his risk assessment is higher with a 9. When I look at his criminal history, I can tell you he has at least 1, 2, 3, 4 outstanding bench warrants. Now, all of those are non-extraditable, but they are also all for failures to appear out of different states. Looks like related to misdemeanor, either traffic offenses, damages to property. One's out of New Mexico, one's out of Texas, one's out of Arizona, 2 out of Arizona. And again, they all reflect failures to appear. His actual history, he was arrested in 2024 for driving on a suspended driver's license out of Arizona. It has no disposition. Again, an arrest for driving with suspended driver's license plus criminal damage out of Arizona in 2023. Most likely there's another one in 2019 arrest for criminal damage defacing out of Arizona. I believe that is the one that has the warrant attached to it. He's got older history of convictions for possession of marijuana out of Texas in 2002 and convictions for resisting and evading arrest back in 2001 out of Texas. So older history. However, those compliance issues certainly raise a red flag to the state. Then the use of the showing of the firearm in this case, the state does believe that $10,000 is appropriate with the no firearms or weapons clause.
For the defense.
Your Honor, we're asking for Mr. Haragi to be released on his own recognizance. I understand, that he's got those failures to appear, those warrants out of other states, but he didn't score for FTAs in the past 2 years. And his most recent history shows that he's stabilized. We were able to reach out to his reference, Edwin, it's his coworker. Edwin confirmed his job, his address, and his phone number. So that score that looks a little higher on the pretrial risk assessment tool is actually closer to like a high-low or a low-moderate. he is willing and able to comply with supervision, including stay away from these people that it doesn't really sound like he knows. No weapons, no firearms. He was arrested with his dog, and his dog was seized by the pound. Obviously, he's worried about getting his dog back. So, you know, given that he is employed and we have a stable address and a verified phone number, he doesn't score for any violent offenses in the past 10 years, no felonies, and he doesn't score recently for failures to appear. I think that supervision and checking in is appropriate. He can come back to court on these matters.
Well, I'm concerned with the multi-state record of not handling court matters in the past. That, in addition to this, involves a weapon that he was carrying improperly, and he's very lucky that it didn't escalate the situation and get worse, as the other individual in the car had a gun as well. So I'm very concerned about the totality of the circumstances, and I believe that some bail is necessary to ensure he appears. I'll set it at $3,000.
Your Honor, I
That's-
don't have anybody.
I understand, sir. The state's asking for much, much higher bail than that. But when you haven't shown up in multiple states, and this is a weapons allegation, this is what I would frankly set for a misdemeanor case. So I'm giving you a big break, in my opinion. It'll be $3,000. That's bondable or 10% cash, no weapons, and Reno Justice Court monitoring if he posts.
Have a good day, Judge.
Next, we have first appearance for Caleb McCarger.
He's waiving his appearance this morning.
All right, probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Your state's asking for $10,000. We're not seeking any conditions. That is based on the defendant's scoring of a 12, and obviously the underlying facts of the case, throwing rocks at ambassadors. He did receive maximum points for failures to appear. He was just convicted on March 3rd of obstructing and resisting, as well as sitting or lying on a public sidewalk out of Reno Municipal Court. He's got an obstructing and resisting conviction last year in 2024, out of Reno Justice Court. In 2024, he was also convicted in April of that year of battery on a protected person out of the Second Judicial District Court. They tried to get him into mental health court as a condition of that case. So they rejected him. So he ended up doing 364 days in jail on that case, and lots of other convictions in Reno Municipal Court for drug paraphernalia, obstructing and resisting. They've tried to put him in community court, tried to help him there. He has FTA'd and been revoked off of those sentences. So at this point, the defendant continues to display violence. So the state believes the $10,000 is appropriate.
For the defense.
Your Honor, Mr. McCarter is homeless, and he's been homeless for a very, very long time. I'm sure the court is aware of his history. He's 37. He's been living in Reno for almost all of that time. He's always in our area. This is where he has ties to the community. I understand that he was sleeping and the ambassadors were trying to move him. And that's when things went wrong. You know, I get his history. I think $10,000 is excessive considering the facts of the case. I understand that he has a problem coming back to court. Any amount of bail that the court imposes on him is going to be a no bail hold. He's never been able to post any amount of bail. So I'm just asking the court to consider his circumstances when deciding what's appropriate.
I understand. However, we've seen people hit in the face by rocks that end up with orbital fractures, brain damage, all kinds of things. And this isn't just him being homeless, it's him being violent. And he's had a long history of people trying to intervene and those interventions being unsuccessful. So given the violence here, I've got to set a bail, and given the long history, I think $10,000 is appropriate. And if he posts, he'll be supervised by pretrial services and can't have weapons. Next, we have a first appearance for Damian Walker.
This is the case I was thinking of earlier, Your Honor. This is the one that we've identified a conflict. I've sent this information over to the alternate. He's in custody on a couple of other matters. He's got a $30,000 bondable hold out of this court and that juvenile probation hold. I would submit that there's very little prejudice to setting this over to Monday or Tuesday.
Well, what I'm gonna do is I'm just gonna set an interim bail, and then whenever the APD wants to show up and handle it, we'll handle it whenever they appear. But often they've been a little better at appearing, but often it won't happen. So I'll set an interim bail, and then whenever they want to come and handle it, we'll be happy to hear it. Ms. Costa, what's your recommendation for an interim bail?
Your Honor, we're seeking $5,000. We're not asking any condition for
All
any
right.
conditions.
The interim bail will be $5,000, and then if the APD, whenever they want to address it, we're happy to hear it. Next, we have a first appearance for Richard Wilson.
I would ask that we trail this unless the state doesn't intend to get into the criminal history too much.
I don't, Your Honor. I'm actually going to be recommending an own recognizance release with check-ins.
All right, so let's go forward. Probable cause is found, public defenders appointed. Let's start the bail hearing with the state.
Your Honor, he does score a 7 on the risk assessment. He does have significant criminal history, but taking into fact the elements of or the facts of the case, the state is not going to object to an own recognizance release. We would ask for check-ins.
So, Mr. Wilson, I'm
Yeah.
going to release you, but your case is not over with. You have to show up at your next court date, which I'm going to set for April 1st at 9 a.m. You cannot have any more weapons, and you need to comply with parole and probation.
Okay.
So whatever they ask you to do, you've got to do, and you've got to come check in with the Reno Justice Court by 5 p.m. on Monday to make sure we have good information to contact you. So
Okay.
Reno Justice Court monitoring, come see us Monday at 5, comply with parole and probation, no weapons, and show up at your next court date.
All right, thank you.
Thank you. Next, we have a first appearance for Keelan Benson. Good morning. Probable cause is found, public defenders appointed. Let's start the bail hearing with the state.
Thank you, Your Honor. State is asking for $20,000 along with pretrial services, supervision, and testing for controlled substances. You can see the amounts of controlled substances outlined and the types in the probable cause declaration. Coupled with those facts are the NPRA is a 12. He is a 12. He does have that hold out of Clark County for possession of a gun with altered or removed serial number, as well as carrying a concealed weapon. That hold is related to a 2020 arrest for those offenses, again, out of Las Vegas. He was convicted of obstructing and resisting out of Reno Municipal Court in 2025. He's got several arrests out of Clark County in 2020 that don't show any disposition, including that one I just told you he has the hold on. And then he's got a 2018 obstructing and resisting conviction out of Sparks Municipal Court. So obviously based on that hold, based on he's only 25 years old and he's accumulated this criminal history so far. So the state does believe based on the amounts found on or around the defendant that the $20,000 with pretrial services and testing is appropriate.
For the defense.
Your Honor, we're requesting that the court either release Mr. Benson on his own recognizance or consider setting a bail that is more in line with his ability to post at $5,000. Mr. Benson did score a 12 on the pretrial risk assessment tool, but we were able to verify quite a bit of his personal information, including his address and his employment and his phone number through his aunt. She confirmed that he has been living on Catterley Lane and that he is employed. She confirmed his phone number as well. So rather than scoring in the high risk category, I think he's probably in the moderate risk category instead. We think that some amount of supervision is appropriate. I think that checking in and testing for drugs and alcohol would be appropriate. If the court wishes, Mr. Benson is also willing and able to submit to other types of supervision like house arrest. But Mr. Benson does need to get back to work, and he is willing and able to come back to court and show up and do what he needs to do. I note that he didn't score for any FTAs, even though he has this warrant.
Well, he has a warrant and it's for weapons related allegations, and he's found by law enforcement allegedly with a number of different substances and a large amount of cash. So I think he also scores a 12 on the risk assessment. So given the totality of circumstances, I believe there's both tendency for a flight risk and risk to the community. I will set the bail at $20,000, will be bondable or 10% cash. If he posts, he'll be supervised by pretrial services, no weapons, and tested for drugs and alcohol. Next, we have a first appearance for Laura Brenton. Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Your Honor, we did reach out to the victim this morning and gave him notice of the bail hearing. We have not heard back yet, but based on her risk assessment score of 3 and no criminal history, state is not going to object to releasing the defendant on her own recognizance. However, we are seeking a no contact order pursuant to statute for 90 days. Obviously, if the victim wants that lifted or if they can take steps to have that, but at this point, that seems appropriate, as well as a no firearms or weapons clause.
So I am going to release you, Ms. Brenton, but your case is not over with. I'm going to set your next court date. That is going to be April 1st at 9 a.m. Make sure you are here. I am going to impose a no contact order with Grammy Brenton, so you cannot have any contact with him whatsoever, not in person, not on the phone, not through social media or through family and friends. That is through NRS 1784845 for 90 days. So what that means is if you violate that, you could be prosecuted for an additional charge over and above this one. And you are not allowed to have any weapons, and you have to report to Reno Justice Court by 5 p.m. on Monday, so we can monitor you and we make sure we have all your correct information to ensure you appear at your court dates. Thank you. Next, we have a first appearance for Cameron Duan.
Morning, Your Honor.
Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Your Honor, the state is seeking $5,000 along with pretrial services and monitoring with a no contact order with the victim. The defendant scores a 9 on the risk assessment. What I can tell you about his history is that in 2025, he was convicted of aiming a firearm at a person, a gross misdemeanor conviction. That was July 8th of last year, along with a trespassing and an assault in the 4th degree. That was out of Washington State, and harassment. In 2021, he was arrested for felony assault with a deadly weapon with force out of California. It shows that he underwent some type of diversion and he was able to successfully complete that diversion, and that offense was dismissed in 2023. Same thing occurred for his arrest on violation of a court order and contempt violation of a protective order. Both of those show the same thing, meaning he got diversion, was successful in 2023. However, the underlying facts of both of those cases, meaning the charges, especially his conviction just in 2025 with aiming a firearm at a person, certainly supports the defendant's ongoing behavior in this case, which was violent as well. So the state believes the $5,000 along with pretrial services and no contact order with the victim is appropriate.
For the defense.
Your Honor, we're requesting an own recognizance release for Mr. Duhan. He can and will comply with a no contact order. It sounds like he and this person encountered each other at CARES, but they don't really know each other. So Mr. Duhan does not have any problem staying away from this person. While he does currently score a 9 on the pretrial risk assessment tool, speaking to him, it sounds like he's supposed to be starting an apprenticeship starting next month. He's going to be learning a new skill so that he can try to, better his life, so that he's not staying at CARES anymore. He's going to be entering into tattooing apprenticeship. He's 27 years old. He can stay somewhere else. He doesn't necessarily have to stay at CARES. He can come back to court and, if the court feels more comfortable imposing conditions like no weapons or even drug and alcohol testing, even though there's not really a nexus here, just keep an eye on him and make sure that he comes back to court. He's willing to.
the criminal history is concerning. I don't know that there is significant stability in this community yet. And this was a violent allegation, which was caught on video. So I think likelihood of conviction is high. So I'm going to impose a bail, but I'll take into consideration some of the other things. I'll set it at $3,000. That's bondable or 10% cash. No contact with Justin Davis and Reno Justice Court monitoring if he posts the bond. Thank you. Next, we have a first appearance for Tabitha Guy.
Good morning.
Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Your Honor, the state is seeking $20,000 bail for Ms. Guy, along with pretrial services supervision. We would ask for a no contact order, which would be imposed immediately while she's in custody, as well as pursuant to statute for 90 days upon her release. We'd also ask for no firearms or weapons. Those conditions in that bail are based on the probable cause declaration, which show this ongoing conduct for some time. It looks like, I'm not sure why, but they continue to have contact with each other to the point where the victim finally got frightened enough to go to the police and report some of this conduct. I understand she scores a 1 on the risk assessment. She does not have any criminal history, but the behavior displayed is certainly egregious and a public safety risk. We did reach out to the victim to notify him of the hearing. We did notify him of the hearing, and he has not gotten back to us this morning. I will note that I know that this defendant and the victim have talked on jail phone calls since her arrest. So again, we are seeking that immediate no contact order with the victim.
For the defense?
Your Honor, Ms. Guy and the victim in this case live on opposite sides of town. She doesn't live with him. She lives with her teenage son and his girlfriend and their child. She scores a 1 on the pretrial risk assessment. All of her personal information was verified. This appears to be her first lifetime arrest. I am asking that the court consider releasing her on her own recognizance with conditions. Obviously, she should have no contact whatsoever with the victim in this case. She and I have talked extensively about that and what that means, and she's willing and able to comply with that. We're also asking if the court thinks that conditions are appropriate besides the no contact order, including no social media, no electronics. She's willing to do that too. Her son relies on her to get around. He doesn't have a driver's license. He's the one that's working. My client doesn't work right now, but she has a valid driver's license and she's trying to teach her son to drive so that he can get a driver's license. With all that being said, you know, her son and his girlfriend have a young baby at home that my client helps take care of because he works and his girlfriend works. So with all that being said, we're asking that the court, like I said, release her on her own recognizance with any conditions that might be appropriate to ensure the safety of the victim and her return to court.
Oh, this is a hard decision to make. Ms. Guy, you need to pay attention when I'm speaking. This is a hard decision to make because this alleged conduct is horrible. And continuing to have contact with Mr. Ibarra while you're in the jail shows me that maybe you are unable to keep from contacting him, in addition to the allegations. So I'm half a mind to keep you in jail because you just simply won't follow these orders. However, you score a 1 on the risk assessment and I hear you have no criminal history. I'm going to give you one opportunity to handle this case out in the community. But if you violate these no contact orders, I will not hesitate to put you back in jail. Do you understand that?
Yes, ma'am.
And I don't care if he calls you, you cannot answer. I don't care if he comes to approach you. I know you both work at the same factory. You cannot respond. You've got to walk the other way because you will be the one be held responsible, not him. Is that clear?
That's very clear.
And if you show me you cannot follow these orders, it won't matter to me who you're helping take care of or what your living situation is, or that you have no criminal history, because then you will have shown to me that you can't listen to the court. So I'm going to release you. No contact whatsoever with Jesus Ibarra, and that's pursuant to statute for 90 days. What that means is if you violate that, including phone calls or social media or anything else, you can be prosecuted for an entirely separate offense. You're also going to have no weapons. You're going to be supervised by pretrial services, and I'm going to give you your next court date. You've got to show up April 1st at 9 a.m. and follow all these rules, or else you can go back to jail. So make sure you understand all those things.
I understand.
Thank you. Next, we have first appearance for Shaquan Mann. Good morning. Probable cause has been found. Public defender is appointed. Let's begin the bail hearing with the state.
Your Honor, state seeking $300,000 bail with no 10% cash alternative, along with pretrial services supervision with house arrest and GPS prior to release, no firearms or weapons, and testing for controlled substances. That is based on the facts of this case, which are egregious. There are numerous substances found in the defendant's possession or near possession that he admits to possessing, admits to bringing the drugs into our community to sell to our community members, including fentanyl, methamphetamine, heroin, and marijuana. He scores an 8 on the risk assessment, but we know that he, in 2022, was convicted of possession of drug paraphernalia out of Reno Justice Court. 2021, he was convicted off living off the earnings of a prostitute out of our second judicial district court. He went to prison on that case. Sounds like he got out about 2022 on parole. He was also convicted that same year of attempted kidnapping out of our second judicial district court, for which he went to prison. He then has a conviction in 2014 for felon in possession of a firearm or unlawful transportation of a firearm. That is a federal conviction. He was received 46 months of prison for that term, and then was placed on supervised release. He's had violations of that supervised release. In 2018, he went back to prison for that. 2019, he had a violation of probation related to that offense as well. And then finally, back in 2011, felony conviction for robbery. That was out of California. He received initially probation. He was later revoked and sent to prison on that, and has an associated parole violation in 2013. So the defendant, multi-convicted felon, has issues complying with any probation, parole, whatever he is placed on. Here again, he's found essentially almost bringing these drugs into our community to sell. So the state believes the $300,000 with those conditions is appropriate.
For the defense.
Your Honor, Mr. Mahan is actually misscored on the pretrial risk assessment tool. He should have been a 7, not an 8. I understand that this is, there's a lot going on here, Your Honor. My client does not have any money that he can post towards his bail. There can be conditions that would ensure his return to court. He doesn't, he scores for prior felonies and misdemeanors, but he doesn't seem to score for prior failures to appear. And it sounds like he comes back to court even when it looks like he's going to prison. With all that being said, I would ask, I understand that this is probably not an OR case, considering how much, drugs and guns were found in the car with him. But we're asking that the court set a monetary bail that's, more in line with my client's ability to post, something closer to $15,000.
Well, these are very serious allegations involving very large amounts, category A amounts of controlled substances. He has a violent record. He's already served a number of prison stints and has been unsuccessful with compliance in the past. In addition, there are numerous weapons allegations here, and there's little stability in our community. So I think that monetary bail is appropriate for all those reasons. I will set it at $300,000. It's bondable only. If he posts, he'll be supervised by pretrial services, no weapons tested for drugs and alcohol, and on a GPS location device for house arrest before his release. Thank you. Next, we have a first appearance for Andres Martinez. Good morning. Probable cause has been found. The public defenders have put in. Let's begin the bail hearing with the state.
Your Honor, state is asking or seeking $100,000, again, with no 10% cash alternative based on the defendant's charges and conduct. Again, we have a larger amount of controlled substances in this case as well. This time there's baggies filled with methamphetamine, scales, an amount of fentanyl, money. Certainly looks like the defendant is selling drugs in our community. He scored as an 8, but was overridden due to his criminal history. We know that in 2025, just in February of 2025, again, this is another individual with a federal conviction. That federal conviction is from 2017, unlawful transport of a firearm. In 2017, he received an 87-month sentence for that case, as well as 36 months supervised release. He did have that probation violation, which is what I'm starting to talk about, in 2025 related to that federal case. He was revoked, sent back to prison for 6 months. Prior to that, he had a gross misdemeanor conviction for taking a vehicle without consent out of our second judicial district court. That was in 2015. Disturbing the peace, domestic battery, and possession of drug paraphernalia also that year. He's got a felony conviction for attempted robbery with a deadly weapon out of our second judicial district court back in 2003, in which he did a 96 to 240 month prison sentence on that case. And then another taking an auto without consent back in 2000. So again, multi-convicted felon, recently convicted of having firearms, and I'm not sure if he's still on federal probation or not, but very recently was. And then having these amounts of controlled substances in his possession, the state believes a higher bail is appropriate. We're seeking $100,000 with no 10% cash alternative, pretrial services with testing. We would also ask for a house arrest and GPS prior to release based on the seriousness of the case.
For the defense?
Your Honor, while my client scored a moderate and was overridden to high, I think it's probably more appropriate that he's a low overridden to moderate. We were able to verify all of his personal information with his mother. She confirmed that he has just started a new job at a masonry place. Doesn't remember exactly the name of the place, but he is working as a mason. What did you say?
Satoro Masonry.
Satoro Masonry. She also confirmed his address. He lives with her, and his phone number. He intends to, well, the address that he stays on Mariner Cove, and she was able to confirm that. We are asking that the court set bail closer to $10,000. I understand that he has a history. This looks like it started out as a DUI investigation, but obviously it turned into more of a drug investigation. And if Mr. Martinez hopes to earn, a gainful living that is going to be more in line with a member of society that we would like to see, he needs to get back to that work. So that is our request today: testing with drugs and alcohol, checking in, no weapons, obviously, and any other conditions that the court thinks are appropriate, including GPS or house arrest.
Well, he's got a lengthy history, including drug-related offenses. The history is serious, and I don't think there's much stability in the community. I hear he may have a new job. He may be living with his mother, but that combined with the history and the large amount of drugs here, including the approximately a little over $500 cash found in his vehicle, and the scales, I believe it's relatively clear that the allegation for sales is supported. So I'm going to set the bail at $100,000. It's bondable only. If he posts, he'll be supervised by pretrial services, tested for drugs and alcohol, and on a house arrest, a GPS location device before his release. Thank you. All right, counsel, I believe that was it for everyone this morning. Any clarifications or anyone I forgot?
No, Your Honor.
No, Your Honor.
All right, thank you all. Have a good day.
Thank you.
You too.